Hello and welcome to Verdictum. This is Kanchan and today I am going to explain to you a few interesting judgments of this week from the Supreme Court. The court directed that the High Court shall frame the directions given in the above mentioned case in form of notifications and guidelines to be followed by the Sessions Court and all the other criminal courts dealing with various offences. Furthermore, the court has also directed the DGP in all the states to ensure strict instructions in terms of the directions which are issued. Both the High Courts and the DGP of all the states shall ensure that such guidelines and directive circulars are issued for guidance of all the lower courts and police authorities in each state within 8 weeks from today. The bench comprising Justice S. Ravindra Bhatt and Justice Arvind Kumar directed. In this case, the appellant and the first respondent were married, with the wife's father interfering and pressurizing the family. A complaint was filed against the wife's family for threatening the husband's family. The wife then also filed a complaint against the husband and his family. The husband claimed that the police didn't follow the Supreme Court's guidelines in lodging the FIR. He faced charges under Section 498A, 323, 504 and 506 of IPC and Section 3 and 4 of the Dowry Prohibition Act. After applying for bail, his plea was rejected by the Sessions Court, but he obtained interim bail from High Court, failing to reveal the dismissal of his previous bail application. Consequently, the High Court directed him to surrender. The criminal appeal was filed challenging the direction of the High Court. The Supreme Court held that the High Court erred in rejecting the applicant's application for anticipatory bail. The court also found out that there were no startling features or elements that would disentitle the applicant to bail. The court also found out that the appellant had cooperated with the investigation and there was no impediment to granting bail once the charge sheet was filed. The court has issued a set of directions to all the state governments and high courts to prevent the misuse of Section 498A of the IPC, which deals with cruelty to married women by their husbands or in-laws. The court has directed that police officers should not automatically arrest the accused in cases of Section 498A but should satisfy themselves with the necessity for arrest. The court has also directed that the police should forward a checklist to the magistrate containing the reasons for arrest. The magistrate should only authorize detention after pursuing the report furnished by the police. Accordingly, the court allowed the appeal and directed the police officials and the trial court to comply with the above mentioned guidelines for granting bail. A Supreme Court bench of Justice A.S. Bopanna and Justice M.M. Sundaresh have observed that when a decision is taken by a competent authority in the public interest by evolving a better process such as auction, a right, if any, to an applicant seeking lease over a government land evaporates on its own. It has also held that applicant cannot have an exclusive right in seeking a grant of license of a mineral unless facilitated accordingly by the statute. In his case, the appellant approached the apex court seeking to overturn a decision by the division bench of the High Court, through which the bench declared Rule 410 and Rule 73 of the Rajasthan Minor Mineral Concession Rules 1986 as unconstitutional. Applications were invited in 2003 for leasing out minor minerals and numerous individuals submitted their application. However, in 2007, a notification was issued rejecting applicants for leasing sandstone in 4 villages, citing Rule 65A of the rules. This led to the writ petitions filed in High Court of Rajasthan. The High Court quashed the 2007 notification, stating that the restriction on leasing sandstone for only 4 villages lacked justification for mineral development. The court directed authorities to revive the application and consider them in accordance with the law. In 2011, amendments were made to the rules and government orders provided relief to those who approached the High Court. Some other applicants challenged these orders seeking similar benefits. In 2013, the High Court held that the earlier decision applied to all parties, subject to considering pending applications as per the amended rules. However, in the same year, a new notification declared all previous applications as rejected, except for certain categories eligible for preference, and allowed 50% of the lease to be granted through auction. The High Court declared these amendments as illegal due to the lack of hearing for the applicants, failure to revive applications based on legitimate expectations and vested rights. The apex court observed that it is far too settled that there is no right vested over an application made which is pending seeking lease of a government land or over the mineral beneath the soil in any type of land over which the government has a vested right and regulatory control. Further, the court took the stance that legitimate expectation is a weak and sober right as ordinated by the statute. In that context, the court observed that when the government decides to introduce fair play by way of auction, facilitating all eligible persons to contest on equal terms, certainly one cannot contend that he is entitled for a lease merely on the basis of pending application. Finally, the court observed that the decisions of the High Court rendered earlier did not stand in the way of the impugned amendments, as they were with respect to the sandstone alone, while the impugned judgment, the High Court applied it to all the minor minerals. It was further said that there is neither a right nor it gets vested through an application made over a government land. Law does not facilitate hearing the parties in bringing an amendment by an authority competent to do so. The High Court, in our considered view, has totally misconstructed the issues, ignoring the fact that there is a delegation of power to the first appellant, which was rightly exercised as conferred under Section 15 of the 1957 Act. In light of the same, the impugned judgment was set aside. A Supreme Court bench of Justice Suryakant and Justice J.K. Maheshwari have observed that only fundamental determinations of the court are hit by res judicata in subsequent proceedings. It was further held that if the court makes any incidental, supplemental or non-essential observations which are not foundational to the final determination, the same would not tie down to the hands of court in future. In that context, it was said that by now it is globally settled principle of the common law jurisprudence that only determinations which are fundamental would result in the application of the doctrine of res judicata. Only those findings without which the court cannot adjudicate a dispute and also form the vital cog in the reasoning of a definite conclusion on an issue on merits constitute res judicata between the same set of parties in subsequent proceedings. However, in the court process of arriving at a final conclusion, if the court makes any incidental, supplemental or non-essential observations which are not foundational to the final determination, the same would not tie down the hands of the courts in future. In this case, the appeals were directed against a judgment passed by the division bench of the High Court, whereby the intra-court appeal preferred by the state of Telangana and its revenue authorities was allowed. The core of the dispute was a resumption order, which confirmed the assignment of non-occupied land in the 1960s to landless scheduled caste and scheduled tribe persons, which were appellants in this case, for the purpose of cultivation. The appellants received a show cause notice from the collector, but later the district revenue officer deemed it invalid. Subsequently, a second show cause notice was issued to the appellants. They contended that the second SCN should be dismissed based on the principle of res judicata as it pertained to the same subject matter as the first SCN. The apex court found out that the cause of action in the second SCN was different from the first SCN, since the High Court has held that the first SCN was issued without jurisdiction and set the same aside. Instead of dealing with the resumption of order on merits, relying in the case of A. Jitendranath versus Jubilee Hills Corporation House Building Society, the court held that the doctrine of res judicata would not be applicable as an order being a nullity never existed in the eyes of the law. The court also emphasized that any determination, despite being deliberate or formal, cannot give rise to the application of the doctrine of res judicata if they are not fundamental in nature. In light of the same, the court noted that on a plain reading, the High Court's order dated 21/4/2006, in conjugation with the application to the test formulated above, we find that the observation in respect of the GPA in the said order was indeed a mere collateral finding. On the issue of whether the second SCN would be barred by the extended doctrine of constructive res judicata, the court observed that it was not applicable to the case at hand, since the issues raised in the second SCN were never adjudicated upon. The court also made observations regarding the test to distinguish between a fundamental or collateral determination, which was hinged in the inquiry of whether the concerned determination was so vital to the decision that without which the decision itself cannot stand independently. In that context, it was said that any determination, despite being deliberate or formal, cannot give rise to the application of the doctrine of res judicata if they are not fundamental in nature. Subsequently, the appeal was dismissed. The two-judge bench comprising of Justice Aniruddha Bose and Justice Bela M. Trivedi observed, as a matter of fact, such an interlocutory application seeking discharge in the midst of the trial would also not be maintainable. Once the cognizance was taken by the special judge and the charge was framed against the accused, the trial could neither have been stayed nor scuttled in the midst in the view of Section 19(3) of the said Act. In the instant case, though the issue of validity of the sanction was raised at the earlier point of time, the same was not pressed for. The only stage open to the respondent accused in that situation was to raise the said issue at the final arguments in trial in accordance with the law. The respondent was working as an executive engineer in Karnataka Urban Water Supply and Drainage Board, Mandya Vision, Mandya during the period of 1983 to 2007. Based on the source report submitted by then Deputy Superintendent of Police, a case came to be registered against the respondent under Section 13 of PCA. It was alleged that he amassed wealth disproportionate to his known source of the income during his office tenure. The respondent filed an application seeking his discharge from the aforesaid case, contending that neither the contents of the said report nor the other documents constituted any offence as alleged, and that the sanction was issued by the government without any application in mind. The said application was dismissed by the trial court, and being agreed by the same, the respondent preferred a criminal revision petition before the High Court, which directed the trial court to consider the documents of the respondent while framing the charges without being influenced. The court added that findings recorded by the special judge could not have been or should not have been reversed or altered by the High Court in the petition filed by the respondent challenging the said order of the special judge in view of the specific bar contained in subsection 3 of Section 19, and that too without recording any opinion as to how failure of justice had in fact been occasioned to the respondent. As a matter of fact, neither the respondent had pleaded nor the High Court opined whether any failure of justice has occasioned to the respondent on account of error, if any occurred in granting the sanction by the authority, said the court. Accordingly, the Apex Court allowed the appeal and set aside the order of the High Court and directed the special judge to proceed with the trial from the stage it had stopped in accordance with the law as expeditiously as possible. Thank you, and keep watching Verdictum, the dictum of truth. Subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with the latest legal developments.